I now yield myself 5 minutes to talk about the issues of the day. I find this hearing extremely interesting. I'm learning. I have a lot of skepticism, and I am affected indirectly. I represent Spring Hollow Reservoir, the land that Spring Hollow Reservoir is on. That is run by the Western Virginia Water Authority. The Western Virginia Water Authority tested in 2020 and found that they had, shockingly, didn't know where it came from. They had Gen X as they traced it down, but they didn't even notify the public in 2020 because it wasn't listed as being something they needed to notify the public about until 2022. They then notified the public as they tracked it down. They found that it was your Chemours plant that had sent tanks, if I remember correctly, to a company called ProChem upstream in Roanoke County to be cleaned out because they had a buildup of calcium and magnesium. ProChem was not advised, as I understand it, based on the press reports. It was never advised that that Chemours had PFAS or Gen X in this case, and that they should be on the lookout for Gen X. As a result, Spring Hollow Reservoir was contaminated. ProChem stepped up and put $1.9 million into trying to resolve the problem in the Spring Hollow Reservoir. Raises a couple questions for me. Mr. Mehan, from a public water authority, should the Western Virginia Water Authority have known that Gen X was dangerous when they first found it in their water in 2020?
I can't speak for them.
Well, I'm saying generally, should they have known that was
I just want to be clear, most of the people running water utilities are engineers. They're not toxicologists. They're not scientists in the sense of doing chemical research. And if, this wasn't on the radar of society generally.
Okay. So it wouldn't have been, switching over to medical malpractice language, it would not have been the standard of the industry for them to have been alert. No. They tested it, they saw it, they thought it was strange, but they didn't know to alert anybody.
That is
okay.
Correct.
All right. Ms. Bodine, as you know, electric power plants intake, use, and discharge water that already may contain PFAS or Gen X. How can we avoid unfairly shifting the burden of PFAS cleanup to the electric ratepayers as well as the water ratepayers?
You've identified an incredibly important issue, which is that, yes, because PFAS is ubiquitous, it's going to be in residuals generated by entities that are not intentionally using PFAS.
Kind of like my ProChem people, they had no idea. They were cleaning out calcium and magnesium as far as they knew.
That's not an intentional use, which has been recognized as, by EPA as an equitable principle that you might want to use if you were creating passive receiver liability, that no intentional use, but nonetheless, there are going to be residuals. They're going to be at incredibly low levels, so it's not the entities that you've talked about, like Chemours, which are going to have high levels, or perhaps your textile manufacturers, or the people making Gore-Tex, boots, et cetera, with high levels. It's going to be people who have it in their intake water or have it from sources they don't even know where it's coming from. And the levels are really low, but CERCLA doesn't care. There's no threshold. You're still liable. If you can detect it, you can be held liable.
Yeah. I was really interested in some of the concepts. I liked your idea, and I'm not saying you were promoting it, but you at least laid it on the table, of shifting the burden of proof. And I like that because I'm concerned about what Mr. Falby has raised, because all of my people downstream of the Smith Hollow Reservoir, who they believe that they probably started getting those chemicals in 2014, didn't test for it until 2020, or didn't test at all until 2020, and then didn't know it was a problem until 2022. But every landowner downstream from that site, because they don't put it all into the drinking water, some of it gets just released back into the river, could theoretically be liable. Is that right, Mr. Falby?
Yes, that's correct. And as a matter of fact, just this month, EPA updated its website to include an affirmative, as I can understand it, an affirmative showing that a brownfield grant applicant is not liable for PFOS or PFOA on the property that you're seeking a grant from. And that's not usually how it works. A phase 1 environmental site assessment is not going to say you're not liable. Right, this is a technical document. The last thing consultants do is make legal pronouncements in these documents. So I don't know how that's going to work. I'm very concerned about it.
Well, and I think we need to clarify that, and I probably will have some additional questions for the record at a later time, but my time is up, and I now recognize